if you've ever tried to read a modern legal contract,
Oh, yeah. Good luck with that.
right, or, if you've ever sat through an American courtroom drama and wondered why the justice system here looks like so incredibly different from almost everywhere else in the world, you are in the perfect place today.
We are definitely getting into the weeds on that one.
Yeah, because I was recently reading this really fascinating breakdown of the American legal system. It's by a legal scholar named Young Kang from an excerpt in a book called The Legal Philosophy of the Common Law.
Right, a really foundational piece of writing.
It is, and honestly, it completely shattered how I view the rules that govern our daily lives. So we're going on a deep dive today to figure out why the American legal architecture is built the way it is.
And our mission for this deep dive is to really unpack a remarkable historical paradox. We're going to explore the mechanics of how America inherited this massive, complex English legal system, ripped it apart during Revolution, and then
We're all back together.
painstakingly stitched it back together, yeah. The end result is this highly unique legal structure that sits right on the edge of two completely different worldviews. And, understanding it explains the hidden machinery behind everything from like how you buy a house to how you might serve on a jury.
Okay, let's unpack this. Because
Yeah.
the best way I can think of to visualize what happened at the founding of the country, and, for you listening, think about it like this. It's like downloading a massive ancient operating system from England.
Ooh, I like that analogy.
Right. But instead of just running it as is, the founders immediately tried to rewrite the source code so it could run a brand new, egalitarian, democratic startup.
Exactly.
They kept some lines of code, they completely deleted others, and the messy result is the system you interact with today.
Yeah, that operating system analogy captures the tension of the era perfectly because despite the absolute hostility of the American Revolution, which was obviously a literal war to expel British colonial rule,
Right. Not exactly friendly times.
not at all. But the English common law was already the bedrock of the original 13 colonies. You simply can't wipe an entire society's legal memory blank overnight.
It's just not possible.
No. I mean, the legal scholar James Kent observed that the common law had been recognized and adopted by the people long before the ink was even dry on the Constitution.
Wow. So they were just like stuck with it.
Yeah, they couldn't just delete the software because it was literally the only software anyone knew how to use.
Yeah, but they didn't keep all of it. They absolutely deleted some very specific, highly aristocratic files, right?
Ooh, for sure.
Because you have this open frontier society filled with pioneers who are like obsessed with the idea of equality. They look at the English system and actively choose to discard the mechanisms designed to maintain an aristocracy.
Yeah, the frontier acted as a ruthless cultural filter. A prime example is how they handled the English rule of primogeniture.
Okay, remind me, what is primogeniture exactly?
So in England, primogeniture was the legal mechanism dictating that the eldest son inherited the entire family estate.
Oh, right. So the younger siblings get nothing.
Exactly. And that single legal rule is what kept massive amounts of land concentrated in the hands of a very few wealthy families, generation after generation.
Which sounds very anti-American frontier.
Completely.
Yeah.
In a vast, unsettled American frontier built on ideals of equality and, the constant division of new land, that rule was totally unworkable.
Yeah.
So American courts simply discarded it.
They just threw it out. And they also got rid of the strict English legal guilds, didn't they?
They did.
Because in England, you had this intense division between solicitors, who like handled the paperwork and client meetings, and barristers, who were the only ones actually allowed to argue in court.
Right, the wigs and the gowns and all that.
Exactly. And judges could only be chosen from that elite barrister guild. So the Americans looked at that monopoly and just said, nope, we're throwing that out too.
Yeah, it's too elitist.
But they did hold on to some incredibly complex stuff. For instance, the source text mentions they maintained the historical division between common law and equity. And I think we need to define that for the listener because equity courts sounds like total jargon.
It does, but it's a critical distinction to understand. Under the Old English system, common law courts were extremely rigid. If you suffered a wrong, the common law court could really only do one thing, which was award you monetary damages.
Oh, so just writing a check.
Right. But sometimes money doesn't fix the problem. Say your neighbor is about to cut down a 200-year-old tree on your property.
Right, you don't want to check after the tree is dead.
Exactly. You want a judge to order them to stop. That is where equity came in. Equity courts were focused on fairness and injunctions.
So forcing someone to do something or
Yeah.
stop doing something.
Exactly. And early Americans kept this dual court system because the mechanical function of it was just incredibly useful. They also kept the dense technical vocabulary, the reliance on case-by-case adjudication, and of course, the jury.
Which brings up a massive question. If we hated the British so much in 1776, why keep their private law to settle our disputes?
It's a great question.
It feels a bit like keeping your ex's furniture after a terrible breakup. You know, you cannot stand the ex, but you refuse to throw out a perfectly good sofa because it's just too comfortable.
What's fascinating here is the sheer pragmatism of the early Americans. They kept the structural furniture because they fundamentally understood the mechanics of a functioning economy.
They needed things to work.
Exactly. The jury, for example, was a deeply democratic way to resolve disputes among peers, rather than relying on a crown-appointed aristocrat. They discarded the rules that didn't fit a pioneer society, but they recognized that to have trade, you need a highly reliable, predictable way to settle contracts.
Right.
You know, to define property lines and address personal injuries. The English common law provided that reliable mechanism.
And this is exactly why, for you listening right now, if you get called for jury duty on a civil trial, say like a dispute over a car accident or a breach of contract, you are participating in a tradition that survived revolution.
It's pretty wild to think about.
It really is. It feels completely normal to an American. But having a jury of random citizens decide a private civil dispute is highly unusual in most of the rest of the world.
Yeah, it's an anomaly globally. But, you know, tweaking that old English system worked perfectly well for settling private disputes between a blacksmith and a farmer. Building a brand new government from scratch, though, required an unprecedented approach.
Because you can't borrow the rules for running a state from a monarchy.
Exactly.
And here's where it gets really interesting. This is what the text frames as the Great Split. We essentially built a revolutionary custom-designed house when it came to our public law, but we decided to fill the inside of the house with antique English plumbing for our private law.
That's a great way to put it. And if we connect this to the bigger picture, this dual system is exactly what allowed the United States to survive its infancy and thrive.
How so?
Well, driven by radical European Enlightenment ideals of equality and democracy, America created the world's earliest written constitutional code in 1787. They drafted a federal constitution that fundamentally broke from English tradition.
Right, by establishing a strict separation of powers, creating a presidential system instead of a prime minister, and building a federal structure.
Exactly.
And it worked. I mean, through territorial expansion, a civil war, 2 world wars, and becoming an economic superpower, that written constitutional structure has remained fundamentally unchanged.
It's incredibly resilient.
And the states even followed suit, right? Adopting their own written constitutional codes. So on a macro level, we have this radical democratic constitutional governance. But on a micro level, in everyday business transactions, American judges and scholars still relied heavily on English legal materials.
Yeah, they preserved the stability of the common law for private matters while innovating entirely in public law. But that antique English plumbing you mentioned, it didn't age perfectly. As the country expanded throughout the 1800s and society grew exponentially more complex, relying on centuries of scattered judicial opinions started getting incredibly messy.
Oh, I can imagine.
You had different judges in different states making completely different rulings on similar issues.
So the system just became overgrown. And that leads a group of 19th century visionaries to look at the sheer chaos of case law and decide they need to rewrite the entire thing.
Yes.
The text calls this the Great Codification War.
Right. So in the first half of the 19th century, a serious movement emerged to codify the common law.
And codification means systematically writing down all the laws into a single, comprehensive, organized set of rules that anyone can read, right?
Exactly. Louisiana actually led the way in 1808. But, you know, because of the Louisiana Purchase, their legal roots were French, not English, so they adopted a civil code heavily influenced by the Napoleonic Code.
Which makes sense.
Yeah. Later, in 1824, a legal thinker named Edward Livingston drafted a comprehensive penal code, attempting to completely systematize criminal law. But the central figure in this codification war is a man named David Dudley Field.
Right, Field. He was the prime mover in New York, and his ambition was just staggering. He didn't just want to organize a few criminal statutes.
Yeah, he wanted it all.
He wanted to codify both substantive law, which is like the actual rights and duties you have, and procedural law, the exact steps you take to enforce those rights in a courtroom.
Very ambitious.
He essentially wanted to take this wild, organic, overgrown forest of common law and turn it into a perfectly gridded farm.
And he faced an absolute wall of collective resistance.
Yeah, I bet.
The legal profession, the practicing lawyers and the judges, they fought back aggressively against Field's vision. And to understand why, you have to look at the mechanics of their profession. It wasn't just blind resistance to change.
Right.
The legal profession deeply valued the flexibility of deciding things case by case. If you have a comprehensive code dictated by a legislature, the law becomes frozen. Lawyers feared that a rigid grid of pre-written rules would completely prevent the law from adapting organically to new, unforeseen situations.
I also think there's a huge human element here.
What do you mean?
Well, think about any complex system you interact with at work or in life. Sometimes the people operating a messy, complicated system are the biggest roadblocks to simplifying it, because their entire expertise is tied up in knowing how to navigate that specific mess.
Oh, that's a really good point.
The lawyers knew how to navigate the forest, right? Their value to their clients was their ability to find the hidden paths in the case law. A perfectly gridded farm makes their specialized knowledge somewhat obsolete.
That is a very astute observation of the human dynamics at play, and the resistance was incredibly effective. Field achieved only partial success.
So he didn't get his big farm.
Not exactly. Under his leadership, New York adopted his Code of Civil Procedure in 1848, which standardized how lawsuits were filed, and a penal code much later in 1882.
Okay.
But his ultimate dream, a comprehensive civil code that would dictate all private law in New York, was heavily resisted and ultimately shelved. Although his procedural codes influenced about 30 other states, the 19th century movement to completely replace the common law with a code was largely a failure.
I'm looking at the modern United States, though, and I see massive walls of legal codes. I mean,
Sure.
if you walk into any law library, you see endless volumes of the United States Code.
You do.
So I have to admit, I'm a bit confused. If Field's dream failed, why does it look like the codifiers actually won?
This is where we get to the great illusion of American codification. If you look at the 20th century, the sheer volume of statutes and regulations exploded. Congress organized all federal legislation into the United States Code, or the USC, in 1926. It started as 15 volumes. By 2024, it's 34 volumes. You also have the massive code of federal regulations updated annually. It looks like a code, and it acts like a code, but the author of our source text, Young Kang, draws a massive distinction here.
Yeah, he quotes a civil law scholar named Clarence J. Morrow, who points out that American codes completely misunderstand the true meaning of codification in the continental European sense.
Exactly. In Europe, a code creates new law. When Napoleon commissioned the French Civil Code, the legislature designed a comprehensive, systematic structure from scratch.
It's like building a house from the foundation up.
Exactly. It's the absolute starting point for legal reasoning. A judge in France looks at the code, reads the rule, and applies it to the facts. But in America, our codes are merely compilations.
Wait, so they're not making new rules?
No, the institutions responsible for them are just taking existing statutes, dismantling them, and reorganizing them by subject area. They don't create new law, they just act as a highly technical filing system.
So an American code is essentially just a really, really well-organized filing cabinet of past decisions and legislative acts.
That's it.
The text notes that in the American system, law has absolutely no meaning without judicial interpretation. A decision that relies solely on reading a statute without citing past cases is incredibly rare.
Almost unheard of.
The statute is just the starting line, right?
Okay.
The past cases dictate how the race is run.
Yeah, the American codes wear the outer shell of a continental code, but their soul is still the common law. This reliance on case law created a massive practical problem, however.
Because of the stage.
Yes, because America is a federal system with 50 different states all making their own common law, doing business across state lines became incredibly difficult. Imagine a farmer in Ohio selling wheat to a baker in Illinois. If a dispute arises, whose common law applies?
Oh, wow. Yeah, the rules might be completely contradictory.
Exactly. To bridge this gap, in 1923, a private organization called the American Law Institute began creating what are known as the restatements of the law.
The restatements are fascinating because they are entirely unofficial. They gather the smartest judges, lawyers, and scholars to systematically summarize the law on topics like contracts, torts, and property.
Right.
They review thousands of messy cases and distill them into clear rules that look exactly like a European code.
But crucially, they are built entirely on common law cases, not legislative acts. They sit right at the intersection of civil and common law.
Trying to get the best of both worlds.
Exactly. They seek the civil law goals of making the law understandable, predictable, and accessible across state lines. But they are just summaries of precedent. A judge isn't legally bound to follow a restatement, but because they're so well crafted, judges cite them constantly as a shared reference point. The focus, as always in America, returns to the power of the judge.
And this heavy reliance on judges interpreting past cases brings up the most unique and honestly, currently controversial aspect of the American system.
Oh, for sure.
The sheer raw power of the individual judge. In continental Europe, a court speaks with a single, unanimous, anonymous voice. Just get the ruling.
Right. But in the common law tradition, judicial decisions are the central source of law, and they're deeply personal. An opinion in the U.S. is written and signed by one specific judge.
Which is wild compared to Europe.
Yeah, and the other judges on the panel don't just anonymously agree or disagree. They can write concurrences stating they agree with the final result but detailing a completely different legal reasoning.
Or they can write scathing dissents, laying out a 20-page essay on exactly why their colleagues are fundamentally wrong.
Exactly. You actually see the messy human thought process of the law laid bare. Furthermore, United States courts of last resort, like the Supreme Court, are surprisingly willing to completely overturn their own precedents, much more so than English courts.
Right.
And of course, the jury still plays a massive role in American private law litigation. But this massive reliance on individual judges, juries, and past cases is facing what the source material calls a deepening crisis.
Yeah. The text outlines three major modern criticisms of the common law, and they strike right at the heart of how the system functions. The first criticism is that the common law is inherently past-oriented.
Right.
Because a judge must rely on precedent, what was decided 10 or 50 years ago. The law constantly lags behind social reality. Critics argue it cannot proactively design a better society. It can only react to what has already happened.
And the second criticism focuses on the actual mechanics of finding the law. Critics argue it's incredibly uncertain and rigid. Because judges have multiple, sometimes conflicting precedents to choose from, identical cases in different jurisdictions might get completely different outcomes.
Which feels very unfair to a lot of people.
Yeah. And the third criticism is purely economic. In a highly integrated national economy, having fragmented state laws creates immense barriers. Businesses complain that they have to navigate a completely different set of rules to operate in California than they do in Texas.
It's expensive.
Very. They argue that to make commerce efficient, we need unified national codes, completely abandoning the state-by-state common law system.
We're looking at Young Kang's defense of the system neutrally here, but he provides a really fierce rebuttal to these three critiques.
He does.
Regarding the first criticism, that common law is past-oriented, Kang argues this is just a historicist grand narrative. Essentially, he claims this critique comes from modern legal scholars who want to engineer society from the top down, rather than letting society evolve organically.
And on the second point, the uncertainty and messiness of the law Kang presents a counterintuitive defense. He argues that these exact imperfections are what actually push judgments toward the good.
The good, how so?
Well, because the law isn't a rigid math equation pumped out by a legislature, a human judge can bend the precedent slightly to ensure a fair outcome in a highly specific, highly unusual case. The messiness is the source of its fairness.
Wow, okay. And finally, addressing the economic criticism about fragmented state laws, Kang poses a very stark question. He asks if these critics intend to destroy the cornerstone of the American federal system.
Yeah, he doesn't pull any punches.
He asserts that decentralized local self-government is exactly what has prevented the United States from moving toward tyranny.
So what does this all mean?
Right. I mean, Kang makes a passionate philosophical defense, but aren't the critics making a valid point for you, the listener, today? In a hyper-fast modern digital economy where transactions happen in milliseconds, doesn't waiting around for a judge to decide a specific backward-looking case feel painfully slow?
It's a fair question.
Wouldn't a clear, unified national law that everyone can just download and follow immediately be objectively better for modern society?
This raises an important question, and it really highlights the central tension of the entire text. The source material frames this as a fundamental trade-off that society has to navigate. A unified national code drafted by Congress might indeed be faster and more efficient for interstate commerce. But Kang's analysis suggests that the messy, localized, precedent-heavy system is a deliberate protective mechanism against sweeping, centralized mistakes.
Ah, I see.
If a single state judge in Nevada makes a terrible ruling, it affects a small geographic area and can eventually be overturned. If a central legislature writes a flawed national code, the entire nation suffers the consequences instantly, and it takes an act of Congress to fix it.
That makes a lot of sense. Kang ends his analysis with a really fascinating observation about the modern era, actually.
Yes, the point on natural law.
Exactly. He claims that in the 21st century, people no longer maintain the proper reverence for the common law because humanity has largely abandoned the philosophy of natural law.
Right.
Natural law is the idea that there is a universal objective moral truth out there, and judges aren't just making up rules, they are slowly uncovering that universal truth case by case.
It's a profound shift in perspective. Without that underlying belief in a universal moral truth guiding the judges, the common law can easily just look like a giant contradictory pile of old opinions written by flawed humans.
Which, honestly, is how a lot of people probably see it.
Exactly. And when you view it that way, the idea of codification wiping the slate clean and writing a logical rulebook from scratch looks much more appealing to modern eyes.
Which brings us full circle. We started this deep dive looking at how early Americans dumped aristocratic rules like primogeniture, but kept the deeply human democratic institution of the jury. We explored the Great Split, the dual reality of a revolutionary written constitution governing the state, sitting right alongside traditional English private law governing our daily disputes.
We examined the 19th century codification war, the resistance of the legal profession, and the modern illusion of American codes. We saw how the massive United States Code is really just a well-organized compilation, a filing cabinet, that still ultimately bows to the power of a judge's interpretation of past cases.
It's an incredibly complex, resilient operating system we're running on, which leaves you with a final thought to mull over as you go about your day. Young Kang argues that the common law is losing its reference because society has abandoned the idea of a universal natural law guiding those judges.
Right.
But if that guiding philosophical anchor is gone, what exactly is anchoring the American legal system today? As we enter an era where artificial intelligence can instantly synthesize and summarize millions of past precedents in seconds, will the deeply human, highly localized, delightfully messy system of judges and juries survive? Or will modern technology finally achieve David Dufield's 19th century dream of a perfectly rigid, unified legal code? Thank you for coming along on this deep dive with us. Keep questioning the hidden structures of the world around you.